Sorry, my name is Alex Au. I'm from yawningbread.org, and I'm the fourth person. Is it? You see one? Yeah, the fourth from the bloggers 13. Anyway, listening to everything that's been said up to this point, I think it boils down to three, I wouldn't say dilemmas, but three ways of looking at it, three dimensions to the issue, and each of them is a sliding scale. Where do we want to decide where to put it? The first sliding scale is that between absolute practicality and symbolism. For example, your mention of fitna. You said that, look, even the Europeans wanted to ban it, even though they recognized that it couldn't possibly be banned. You are therefore speaking in favor of symbolism. Whereas the bloggers 13 think we should pay less regard to symbolism and in the interest of protecting the integrity of the law, be more partial to doing what is doable, to regulate only what is regulatable. So that spectrum is one where we have to ultimately agree as a society where we want to pin our final decision between one end and the other end. The other spectrum was raised by basically Cherian. It is, where do we want to put the locus of responsibility? On one hand, you could argue government. That's one end of the spectrum. Only the government and nobody else is responsible. The government takes all the decisions and the government does everything. Yeah. On the other hand, we can say, no, we can argue to move it more towards the private citizen or to various civil society bodies without government involvement. So that is really another overarching decision we need to make. Whether you're talking about films, because I was actually expecting Leong to ask, how are you going to constitute such a body? Before he said yes to it. But there's another example of that spectrum. The third one, more dicey. I wrote down here actually that it sounded to me that your concern was freak election result. But when I think about it, it's another spectrum between acting preemptively and acting post facto. I think the bloggers 13 was more concerned that we should act post facto. In other words, whoever is aggrieved by material and content put up in new media should seek recourse through established channels of law and the courts. If you think that the damage is immediate and you cannot wait for a court decision, then go through the established channels of seeking a court injunction. Whereas the present regulatory system is preemptive but using administrative powers to be preemptive and then not availing and not providing many channels of appeal. So that's a third of the three spectrums. Where do we want to pin it? Between being highly preemptive, ban everything, don't put up anything during our election time, don't put up anything that's even religiously sensitive, or allow more freedom, but also allow recourse. And I think we need to decide on that.
Thank you. Jehan.
Thank you for that. I think it's a very, very good way of casting the discussion here. I just want to say that, although maybe it sounds a little airy-fairy, that perhaps in some respect, where along the spectrum one lies really has to depend to a large extent on the issue in question. And that on some issues I may actually lean to the left, on some I may lean to the right, depending on my perception of the consequences and whether you can actually take steps early enough to prevent the harm from escalating. I mean, so taking an example of the first dichotomy, if you like, that you mentioned, that between symbolism and doing what is doable. Here I actually fall on different sides of the camp, depending on which issue is concerned. For example, when it comes to the so-called infamous ban on 100 websites, I know we haven't gone into that issue yet. There I would say symbolism, to my point, is totally unnecessary, and because it's misleading, the symbolism is misleading, and therefore in that issue, I would not lean towards symbolism, but I would lean on the other side of the spectrum or the continuum, if you like. But when we're dealing with religious issues, I'm not certain if I might agree that I would pitch it in the same way, because I think there's something to be said for the symbolism, because then at least society can say or show or demonstrate that it is being sensitive to the sensitivities of a particular community within the society, and it can actually do something to prevent, or to at least say, we ban it in Singapore, we ban it within our geography, so that people cannot go out and openly sell the video, for example, even if it's posted on YouTube. And I think there's some value, because members of that community may feel very offended. You can find videos of it selling in the stores, for example, you know, or hawking by somebody on the roadside, for example. So I think there is some value in taking a slightly tougher approach, if you like, in that sort of instance, for example.
If I could just add to that, in response to Alex Au, I think it's not entirely symbolic. You know, having a prohibition on certain type of web content. As Cheng Han pointed out, if you say that, since it's already on YouTube, what's the point of having such a law, right? Cannot be enforced. But as he pointed out, you can make DVDs out of that clip that you're producing, that video that you're producing. And if you don't have a law that prohibits that, the DVDs can be made, they can be shown at public forums, and during general elections, you can use that DVD and you can show your election rally. So that's one. Two, if you do have that prohibition, right, even if you are able to put that clip on YouTube, there is a real possibility that you could be prosecuted. So there could be a deterrent effect. Right? You may not be able to completely stop it, mirror sites, whatever it is, but if you have such a law that says, look, this is prohibited, and if you try and use technology to overcome that law, remember that you can be open to prosecution. And three, I think there's one other benefit, and that is if you believe that these are legitimate concerns about the use of internet. I think having such prohibition, can, I believe, over time, help the public better understand and be educated as to where are the areas that we should be treading very carefully and where we should have free rein. So there's some educational benefit arising from that. And maybe this is more importantly the argument for some kind of a condition to be attached to the law. Aims cannot be totally deaf to the voices of those who are fearful of such a regime. As I told you, I got feedback from people who say, look, there are dangers in going in that direction. And earlier I told you, right, I did talk to this young woman lawyer, who said that, look, why do you need to do that? So far Singapore is doing well. Why do you need to change the law? Status quo. MDA is doing a great job. I don't think she's a fool, professional, works as a lawyer. And there are people like the guy I cited. So we cannot also be deaf to that school of thought. I may not completely agree with what they say, but our commitment is to tap the collective wisdom of society and negotiate a cause that hopefully will satisfy the most number of people.